The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this march to draw nigh, give their attention to the court, now sitting.
Thank you, everyone. Please be seated. Good morning, everyone, and welcome to the Kansas Supreme Court. I am Justice Eric Rosen, and as I think you all know, unique to this week's docket is that our Chief Justice, Marta Luker, will not be participating, and I will be filling in for her during her absence. For anyone who is unfamiliar with the court process, I would like to explain that all of us, all the justices, are familiar with the facts of the case, the parties' arguments, and having read the briefs and authorities relied on for those arguments, reviewed exhaustively the district court record, and otherwise prepared for this morning's arguments. We look forward to the parties' oral arguments and our exchange with the attorneys. And I will now ask Mr. Doug Shima, Clerk of the Appellate Courts, to please announce the 9 a.m. docket.
The first case on the 9 a.m. docket for Wednesday, December 17th, 2025 is appeal number 127143, State of Kansas versus Tyler Eugene Kelly, appeal from Sedgwick County.
May it please the court, Lead Assistant Appellate Defender Corinne Gunning appears on behalf of Tyler Kelly, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 126757, State of Kansas versus Jeffrey James Exon, appeal from Shawnee County.
May it please the court, Kristen Patty appearing for the appellate, Jeffrey James Exon, present and ready for argument. Your Honor, may I reserve 3 minutes for rebuttal?
You may.
Thank you.
Thank you, Ms. Patty.
May it please the court, the state of Kansas appears through Assistant Deputy District Attorney Carolyn Smith, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. I will now call the case of State of Kansas versus Tyler Eugene Kelly, case number 127143. Counsel, you may approach.
Good morning, Your Honors. Corinne Gunning, Lead Assistant Appellate Defender on behalf of Appellant Tyler Kelly. And Chief Justice, I would request 3 minutes for rebuttal.
Thank you. 3 minutes will be granted.
For the reasons stated in my brief, I would request that this court vacate Tyler's felony murder and aggravated robbery convictions for insufficient evidence, or in the alternative, reverse and remand for new trial based on various trial errors. In this case, we see a situation involving several young men go horribly awry. What cannot be disputed in this case is that Tyler saved Brody's life. I am using Brody as a pseudonym for the juvenile in this case. But in defending him, he caused the death of another child. While this is tragic, felony murder was not the appropriate charge here. Or in the alternative, Tyler's theory of defense that he was acting in defense of his friend was the appropriate defense for Tyler to have, and he was essentially cut off at the knees in being disallowed from arguing that because there was no instruction given. We see in this case that Brody had a dispute with Joshua, and he and Joshua agreed to fight. Joshua even told Brody to come to his house to box, but Brody testified that he formulated his own plan, one that he did not tell the ride that he requested Tyler that he had planned. Tyler agreed to come to be there for Brody because he wanted to ensure his safety in the event that Joshua made the confrontation otherwise unfair. Tyler was present in the event he needed to help defend Brody, who was unarmed, and his assistance was, in fact, proved to be necessary. Because of the facts in this case, I plan to discuss issue 2 related to the use of force instruction. But the facts for that issue are intertwined with issue 1, so there might be some overlap. But I am prepared to discuss all the issues as this court directs, but would otherwise submit those on the brief. From the very beginning of this case, it was clear that Tyler's version of events involved the use of force in order to defend Brody and ultimately himself. Yet the court cut off that argument by refusing to instruct on use of force as an affirmative defense at trial. The instruction was legally appropriate, it was factually appropriate, and the state didn't meet its burden in this case to prove that it was harmless beyond a reasonable doubt. I would say that the court itself acknowledged that Tyler's use of force defense was legally appropriate. In this situation, we have what the defense counsel in this case described as sort of a turducken situation, where we have felony murder, which in and of itself is not, cannot be, there's no affirmative defense in and of itself to felony murder unless it is a defense to the underlying felony or somehow negates an element of the underlying felony. In this case, we have aggravated burglary as the underlying felony. And while generally speaking, that offense does not have a defense, an affirmative defense, again, we have the target offense of that as aggravated assault, for which an affirmative defense is appropriate in this case. So it negates the aggravated assault in this case element of the aggravated burglary. But the question in this case comes down to whether or not it is factually appropriate. And in this case, the district court erred when it found that it was not factually appropriate, determining that it believed certain evidence over Tyler's evidence. For example, it said that there was no reasonable belief in the need to defend against Shaquille in this case. And that there was no reasonable belief to defend against Joshua because Joshua was lawfully defending himself against Brody's initial aggressor. I would point out that I'm not sure that Joshua had a lawful right to defend himself with a gun, but he was certainly in his house when he was approached by Brody. But in determining that these two facts did not did not make the instruction factually inappropriate, this shifted the analysis in this case inappropriately. Because the question is whether or not there is some evidence to support giving the instruction, not whether or not there is evidence that supports not giving the instruction. And Tyler's testimony in this case alone demonstrates that it's factually appropriate.
Okay, so let's say we agree with you there. Let's skip to harmless. What's your argument on harmlessness?
In this case, the argument on harmlessness is that, I mean, from the very beginning, Tyler's had this as his defense. That was the basis of his testimony. That was the basis of his closing argument. Without the instruction, the jury lacked the context in which to put this testimony in this argument.
Well, couldn't the jury just reject the whole intent if it believed Kelly's rescue narrative?
It could have, but in the event that the court did that, and this is where there's some intertwining with the insufficiency question. In the event that the jury rejected the intent element, we still are lacking whether or not he may have not come there to commit the aggravated assault, but he certainly did at some point possess an intent to defend Brody with his gun, which could be the aggravated assault. So even if he didn't intend to enter the house with the intent to commit an aggravated assault against Shaquille, or that he was there just to defend, I guess, frankly, waving your gun around is an aggravated assault. That if they said at the beginning he never possessed the intent, we get to a point that at some point in time he certainly did commit an aggravated assault. And so if the jury is not told that they can look at that and say, we have a context for why he did that, they can't I mean, if they're following the instructions, they can't simply just ignore that. And I think, I see some questions here. There's a question of whether or not he had intent when he went into the house. And when he arrived at the house. He testified that when he went into the house and then eventually did see Shaquille and the shooting happening. He certainly did commit an aggravated assault at that point. The question would be when that intent was formed. And so I think there's this dual argument. Obviously, the jury did reject that argument, but then didn't have the context for which to place Tyler's actions.
Then they could have just acquitted him, right? They didn't believe he had the intent.
Right. And I don't think that, I mean, and this was the state's argument, obviously, that it also takes away some of the other they could have found that he had the intent, but that it's not for trying to think about this. They could have found that he had intent at some point. And that's the wrestling that we had here too, is that did he have intent to commit aggravated assault when he entered the house? Did he have an intent to commit aggravated assault against who? But the state's argument was, and
What did the jury instructions say about that?
about
Intent to enter the house. I mean, intent when, I mean, what was the jury instruction in defining?
the jury instruction was that Tyler committed the death occurred while Tyler was committing an aggravated burglary, which was entering or remaining within the house with the intent to commit an aggravated assault.
Okay, and so did it define what an aggravated assault was?
Yes.
So I guess I don't understand I mean, if the jury was following the instructions, they could have either acquitted him or convicted him.
That is certainly true. But I think that and this is
I'm just doing all this in the context of
Right.
harmlessness. Would it
Right.
have changed the outcome of trial?
And there is a bit of an overlap here as well to the, I mean, I would say maybe a prosecutorial cumulative error question is that in not giving this instruction, the jury was then also told that what happened in this case, there was no defense to it, that there was this planned attack, and that everything that Brody said was true. And I think there was a struggle in this case between what Brody said about his intent and about what Tyler said he knew and understood when he went into the house. And so certainly they could have simply just acquitted on the intent, but I think that it undermines Tyler's argument when we don't have a context in which to place his argument that he was acting in defense relative to what Brody said his intent when he went in the house was.
Can I ask some factual questions about that? What was the timeline of when he went into the house versus when he alleges he formed the justifiable use of force intent?
I think this is a good this is where there's some divergent things. Tyler's testimony was that he was outside simply waiting for Joshua and Brody to come out of the house. He thought that the fight was going to happen outside. He heard gunshots, and that's when he entered the house.
So if that's viewed in light most favorable to the defendant, there was some evidence of that he
Yes.
did not enter the house until, in other words, he was outside.
Yes.
Because I couldn't tell whether he was outside and his friend was inside.
Yes.
And then there was the gunshot and then he came inside.
Yes.
So my question
Yes.
is, if that's the fact as viewed in light most favorable to the defendant, is that sufficient under our use of force statute to establish the force necessary to defend a person against such others' imminent use of unlawful force? And how did he know? How could he have known if he's outside the house? Under the
that he
statute?
needed, that
Under
he
the-
needed to use force.
Yeah,
His testimony was that he needed to use force. He knew that Brody went in unarmed. And so that any gunshots that were happening were not happening from his friend, that they were happening to his friend. And so that his position is that he knew that he had to do something, because there was some.
and
there
does
was
that
gunfire.
evidence establish, even viewed in light most favorable to the defendant, a reasonable belief that deadly force is necessary to defend a person who's in imminent danger?
From my perspective, I would say certainly if I heard the gunshots in a house that my friend had gone into, and he was unarmed, I would think that there might be a need to defend him from those gunshots that are actively.
Was that particular precise question discussed below when this was being argued?
I do not believe so. And part of why I think there's some confusion about this is because of differing timelines that were presented and differing views of the evidence in this case. But if we look purely at Tyler's testimony, which is where I think the court erred, is not looking at Tyler's testimony in order to give this. But certainly if it is not harmless on its own, I think then when you add in the prosecutor's arguments about use of force and whether or not it applies, we've got at least two errors here that compound upon themselves. I do see that I'm out of time. So if there are no
Any
further
other inquiries,
questions-
colleagues? Thank you, and I know you reserve 3 minutes.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'm gonna focus the majority of my arguments again this morning here in regards to issue 2 as well, but if the court has any questions about the remaining issues, I would welcome them. We'd stand on the brief regarding the sufficiency of the evidence in issue 1, because if the evidence is viewed properly in that issue in the light most favorable to the state, there's absolutely no way that there was insufficient evidence based on the record of this case. And as opposing counsel noted, that does tie into issue 2 a little bit here, because we have the question about what evidence, as Justice Steele, you were asking, what evidence do we have here that could have possibly suggested or like affirmed to defendant that he needed to use force to meet unlawful force? In the state's position, there's absolutely none. To begin,
Before you go down that trail, which I want you to, but do you agree that if we view the evidence from a sufficiency standard in light most favorable to the defendant, which is what we are to do when we consider these kinds of instructions, do you agree that the evidence that is most favorable to the defendant is as was recited? In other words, he's outside the home, he hears a gunshot, and he enters the home. Do you agree with that?
I think that that's a very good question, because the state's response would be no. If you would review the evidence, if I may, I'm sorry.
No, I think we were going in the same place. I just want you to address, your position is there's no evidence in the record that would support that version of events, because I thought there was.
I'm going to answer that in 2 ways.
Okay.
To view the evidence in the light most favorable to the defendant here, I would urge this court to ask itself the question, what version of events are we talking about? Because the defendant himself offered 4 to 5 different versions of events here. One of those was that he wasn't there at all. Arguably, that would be the evidence in the light most favorable to the defendant. But here, yeah.
But if a jury had concluded that he had been outside the house,
Right.
heard a gunshot, and then entered the house, would there have been some evidence to support that finding?
There would be some evidence to support not a finding that defense was justified, but
No, I'm just talking about the
exist.
factual
yes,
scenario.
yes, that is another.
That's the
fact.
factual scenario we need to analyze when we ask the factually appropriate question, right?
Candidly,
That's what I wanted you to focus on.
Yeah, candidly, I don't know, but I will analyze that. I'll go through that. if we were to view the evidence in the light most favorable to the defendant and go with this version of events that he offered, that he's just standing outside by his car while the other end of Brody goes inside to fight. I guess there are a couple things that have to be noted here. In this version of events from the defendant, he didn't even see Brody go inside. In this version of events from the defendant, there was absolutely no agreement to actually go fight inside. In this version of events from the defendant, this was merely going to be some kind of a fist fight outside. In this version of events, what we were discussing here would be mutual combat. That was what defendant was, I guess, reaching for in this version of events that he provided. And under those circumstances, there's absolutely no way, no legal right for Brody to have claimed self-defense. Thus, no basis, certainly none identified by the defense in their briefing or argument here today, that would justify defendant then being able to exercise a right to which Brody himself was not entitled to.
Do we have case law that says mutual combat is an exception to the defense of others, the use of force to defend others?
Can you rephrase the question? Because what's coming to mind is the Bartlett case that I referenced in my brief, and that's the one where a self-defense instruction is not available when the parties engage in mutual combat.
Right.
Yeah.
But that's a self-defense. I'm asking, does mutual combat extend to defense of others? In other words, let's say there is mutual combat. Let's just say this person is a passerby,
yeah,
who sees the mutual combat and comes to the alleged defense of another. Does that mutual combat also eliminate that justification of defense of another?
I believe that it would. I don't, to directly answer your question, Your Honor, I don't know. The state is not aware of any case law that indicates that defense of others would be completely eliminated. But
because as I read the statutes, it looks like that exclusion, the mutual combat exclusion, only applies to the actual person who's engaging in the mutual combat.
I guess I think the best way I can answer that is under those circumstances, legally, I don't see any basis upon which someone that just is just there could then assert a right to defend someone that has no right to defend themselves. Even under whether it's mutual combat or as if passerby seeing the mutual combat to aid to another. There does not appear to be any legal basis for that, respectfully. And I don't believe on the facts of this case that there would be any basis for that either. I guess I would, at this point, additionally, I would like to address, Justice Steele, you'd also asked about the timeline of entry to justifiable use of force. Again, there are a number of different timelines here, but even if we go with the defendant's version where he stands out there by the car, I would point out that in addition to the defendant not being able to exercise the right to self-defense or defense of others because there was this mutual combat going on, the alternative theory version is that he hears shots and then he goes in. In that circumstance, I guess there are two things that the state wants to point out. Just hearing those shots, as the district court here found, the homeowners firing shots to defend their home or themselves in their home would have been justified on the record of this case in particular, but also legally justified. In which case, again, neither Brody nor defendant could assert any right to defend themselves or another. Because the force was lawful. The homeowner's application of force would have been lawful. So there is absolutely no basis for defendant to have claimed as a matter of law or fact that he had the ability to intervene to prohibit the imminent use of unlawful force, period.
And does that go to the legal appropriateness or the factual appropriateness of
I
the
think they're
instruction?
tied together, unfortunately, and that's just even if theoretically there was some legal basis for it, it would not have been legally appropriate to have given such an instruction here because the facts didn't support it, even viewed in the light most favorable to the defendant. I would also point out, Justice Steele, your question, how would he know? How would the defendant have known? And that is the state's point exactly. There's absolutely no way he could have, because in this version of events, there was an instance of mutual combat going on inside. In order for someone engaged in mutual combat to be able to assert a claim of self-defense, that person would have to end the combat, communicate the desire to end that combat, and try to get away or escape that combat. There was absolutely no evidence that Brody did that in this case, and there is certainly no evidence upon which the defendant could have jumped to those conclusions from his location outside by the car. It's simply not possible. And then ultimately, I guess, while certainly there is absolutely a factual mess here based on what was presented by the defendant and the various versions he has offered over time, if we do skip to harmlessness, as Justice Standridge, as you were asking, the instruction here was legally appropriate, hasn't been challenged. The jury was absolutely free to reject any inference of intent. And as the district court here also explained, the jury was also completely free to reject any meeting of minds between defendant and Brody that there was going to go over to be some kind of a fight. There had to be that meeting of minds here in order for defendant to be held accountable. The evidence supported that it absolutely was. Again, there were text messages back and forth between the defendant and Brody plotting for this to be an ambush. And I think that harmlessness is firmly cemented here by, I would also note that the appropriate standard is not what the defense is asserting in this case. The appropriate standard for harmlessness would be the statutory standard, because it's the statutory right to the defense of self or others that's at issue here. That is easily met, and candidly, even the constitutional standard could be met and should be met on the record of this case. If there are no further questions, I would briefly just comment on the claims of prosecutorial error. State will largely stand on its brief on those, as well as the remaining issues that were presented on this appeal. There's just simply no basis for reversal or for granting a new trial on the record of this case. I would welcome any further questions, but if there are none, the state would simply ask that the verdict in this case be upheld, because it was the correct verdict based on the evidence and the law that was presented here.
Any other questions, colleagues? Thank you,
Thank you all
Mr.
very much.
Gillette. Ms. Gunning, you reserve 3 minutes.
Yes, so with the benefit of a couple minutes to collect myself, Justice Sandridge, my a further response to your question is we have two defenses here, potentially. One, Tyler lacked the intent. And then if the jury finds that he didn't lack the intent, that there is a justification for the intent that he had, that these affirmative defenses are justifications for actions that are taken. And so in the event, which the jury did here, appear to reject the question of whether or not Tyler lacked that intent, in that event, they didn't have another, as I said before, the context to put this in as a justified reason for his intent to enter into this house with the intent to commit this aggravated assault.
So I want to ask about that justification.
Yes.
And I think the key statute is 21-5222, right?
believe so,
Which is
yeah.
the use of force against another statute. And I wanted to focus on the last 2 words of subsection A, because that justification is limited to defense of another against, quote, the use of unlawful force. So how can we conclude that this, again, even in light most favorable to the defendant, you hear gunshots after somebody enters a home without authorization. How can we conclude that that is unlawful force when we have other statutes that say a homeowner is entitled to fire a gun in defense of home, and that's not unlawful force based on the limited facts that your client would have had under your version of events.
Right. And this, I think my answer to this would be as the state even noted, and I think reading through this record, you can see that there are it's a factual mess, I suppose, based on different testimonies. The question that I think that we have here about whether or not a homeowner can defend himself, and frankly, whether or not Joshua constitutes a homeowner who can defend himself, and what, like even the question of mutual combat. I think some of these questions that are in there are better factual questions left up to the jury, rather than a factual question to find that this is not factually appropriate. I know that there's a question about whether or not these are actually questions of legal appropriateness. And my response to that would be, I don't think that these questions of mutual combat or any of those are generally ever legally the question. But in this case, we have that Tyler knows that these two have agreed to a fist fight. He knows that his friend went in to presumably institute this fist fight, and then he hears gunshots. He doesn't know the context of how that's happening, and something might have changed once he goes into the house and sees that perhaps Shaquille is taking action somehow. But the knowledge that he has outside the house is that these two young men had agreed to have a fist fight, and he hears gunshots. And so that he enters the house with the intent, potentially with the intent to just kind of figure out and see if he can stop the shooting. But that is a question that is better left for the jury to sort through, potentially with an instruction on mutual combat or on stand your ground law. But that is not something that factually precludes giving the instruction in the first place. And those are actually the two things I wanted to say, if there are no further questions.
Any other questions called? Thank you for your argument. The court will take this appeal under advisement, and what I mean by that is that we will now conference the case at some point today, and a justice will be assigned to draft the decision. That will be reviewed by all the justices participating in the case, and we will continue with additional discussion until a final decision is reached and written, and then that will be published on our website at kscourts.gov. Thank you for your arguments this morning. I will now call the case of State of Kansas versus Jeffrey James Exon, case number 1265757. Counsel, you may approach.
And may it please the court, Kristen Patty appearing for the appellant, Jeffrey James Exon. For starters, I think we can get rid of the second issue fairly quickly. We've got a little bit of a problem where probably a nunc-pro-tunc.
You agree a non-pro-tunc will remedy this?
Yeah, and at least for some reason, I keep all of my e-filing notifications, years worth. And I did check on this last night about 6 p.m. and I don't think that the ones come through. I also mentioned to Ms. Smith before argument, there's another defendant from Shawnee County who's complaining about the way his recap of sentence is done. And that's on a motion for summary disposition before you. So these situations are awkward where we're not going like hard 50 plus so many months. And we have to do something different. So anyway, going to the first issue. The problem obviously for me in this appeal is that my client's own expert says that he cannot avoid entirely culpability regarding the death of his daughter. So I guess we're talking about the degree of culpability and whether it is aggravated child endangerment which would make it which is a felony, it supports the felony murder conviction, or whether maybe if his expert had been allowed to testify to other things, his attorneys might have argued for at least that the jury could be instructed on a lesser included offense of just misdemeanor, Class A.
How could the expert's opinion ever have supported a misdemeanor in this case? Even if the expert had been allowed to say whatever he or she wanted.
The problem in this case is you don't have one single acute event.
No, they were locked in a room with no food or water for 3 days.
It had also been something that had been starting and had been seen in this little
I'm
girl's.
just asking you to, I'm giving you the opportunity. What would the expert have said that could have allowed a jury to find a lower criminal liability?
I think for
I'm having
those,
a hard time imagining what the expert would have said.
I know, and hope you appreciate that I didn't pick this case exactly. For those of us who deal with, say, child in need of care cases a lot, and I know they come before you on occasion, I've acted as a guardian ad litem and an attorney for parents so long ago that it was still called SRS. So I don't know exactly how those cases are handled now. But I've been involved where I think kids have been taken from homes where situations were maybe not even quite this worse. Because started to say earlier, the clues that something was amiss started to appear in this little girl's medical records more than a year and a half before her death. When there's even something that the expert did say that there's a blood test that indicated a type of anemia that's indicative of malnutrition. So this isn't one acute event. You may have seen a news report in the last week or so. 2 people have been charged in Northwest Kansas for leaving a teenage boy with minimal clothing beside the road, a rural road, in the middle of the night last January. That's one discrete acute event. This, however, was something that was building over months
I
and
just-
months and
Go
months.
ahead. Joe.
I just trying to, and I realize you take the case as it comes and the
Mhm.
record is what it is. But I feel like you still haven't answered my question because I don't understand how even testimony about a prior underlying medical condition, given these facts, could possibly allow a jury to reach a determination of a lower criminal culpability.
And maybe they wouldn't have.
No, I'm not asking
Right.
about what they would have done. I'm asking about view the evidence in light most favorable to your client. How could that testimony ever justify? I mean, why does it matter whether the little girl had an underlying medical condition, given the facts in this record?
Well, the expert was able to testify that if she had been at an adequate weight, I think
Yeah, the expert wanted to blame the doctors.
right.
But again, I just wanted to give you an opportunity to explain to why that matters. Let's just assume that her doctors had been negligent. So what?
The expert was able to testify that if the little girl had been on her growth curve in the 60th percentile and she had 4 days of starvation, no, she would not have died in January.
Well, isn't
you're-
the issue here, the underlying inherently dangerous felony is aggravated endangering a child.
Mhm.
So no matter what happens, in the year leading up to it, she has trouble feeding, she has whatever. Why is that even relevant? Because the bottom line is that there was evidence that they were locked in a room. Now I can't find it, but
Certainly there were baby gates all over the house and he was inattentive.
right. I mean, you know, even the older child. I mean, it's aggravated endangering your child. So no matter what, okay, so you know, you say, okay, this kid is diabetic and needs insulin every day. Okay. And so, and then the parent doesn't give the insulin every day. I mean, that's aggravated endangering a child. I mean, just what happened in that 4 days or whenever it was. How can you say that's not aggravating? There's no defense to aggravated endangering a child here.
I will tell you this. I'm not a parent. I've had 3 dogs and a cat. And, I have a little trouble wrapping my head around this as well.
Well, wouldn't the expert have to have testified that even but for the endangerment, this child would have died due to a pre-existing medical condition?
Possibly.
And that's not what the opinion would have said.
No, except only that between the autopsy and what was available in her medical records, there wasn't a investigation done about some things. And I don't remember it exactly now, but I believe she did testify about the different types of tests that couldn't be run because of the state of decomposition that the little girl was found in. And, you know, then of course it was like another 24 hours before the autopsy was conducted. And at that point, there are just some tests that can't be made because there isn't the evidence. The evidence is no longer available.
That has to do with failure to report the death of a child.
Yes. I'm not arguing that you should get rid of that one. You know, one of the things that I didn't brief in this case was, even though his trial counsel had argued it, had to do with whether his statement to law enforcement should have been suppressed. And
Well, it's a
You know,
little late
once-
for that. That's not before us at all.
well, no, I'm only trying to make the
Yeah, but
point
let
that-
me just, what I'm having also some,
Mhm.
obviously there's some challenges presented by this case, but your expert essentially was able to testify as to what your theory of defense is and is that the medical providers should have done more. And somehow their absence of doing more contributed or caused the death. That was put before the jury.
A lot of what they wanted was put before the jury.
Almost everything was, except for the conclusions about this was medical negligence or legal or whatever the negligence. And
Right.
other than that, everything about your theory of defense was put before the jury.
Yeah.
I'm correct in that, aren't I?
Yes, she was able to say a lot of the things. And it's primarily I prepared an appendix for you. And my only problem with the statement was, his 911 call. You can't get that excluded. So his 911 call and the death part kind of is you can't get rid of that. Anyway, I prepared an appendix, which I very rarely do, to the brief that compared side by side the 3 reports so that you could see what paragraphs changed and when. And so certainly on appendix page A4, she was not allowed to testify about what might have been done in assessment of the home environment through DCF. She was not able to testify about the medically negligent part of her opinion, which
Isn't that's my point. In essence, that's what she presented through her testimony. It's just not the conclusion that there was medical negligence, but everything that was testified to by Dr. Bartholomew and her observations of what occurred here with medical providers prior to the death was all put in there.
They got in a lot of what they wanted, yes. I'm about out of time. There are no other questions?
Thank you.
Thank you.
May it please the court, the state of Kansas appears through Assistant Deputy District Attorney Carolyn Smith. Your honors, this is not an easy case to talk about. And the main issue before the court today is whether or not the district court abused its discretion in not allowing Dr. Bartholomew to say specific statements. And it came down to 3 specific statements that the district court made rulings on. I believe everything else within the report was either adjusted by agreement of the parties or the state did not object to it. Specifically relating to the doctor's statements about what DCF would have been required to do or what any possible investigation would have found within the home, the district court determined was either speculation or not based on facts within the case or the doctor's expertise, which in the field of pediatrics was not questioned by the state, was accepted that she was an expert in pediatrics. But there was no evidence before the court that she had direct experience or expert in social work investigation into the homes. And that, I believe, is what the district court took issue with, was that despite her being a mandated reporter or a mandatory reporter, which she was permitted to discuss, she didn't have any direct history working with DCF specifically, and there wasn't evidence that she participated in any investigations into other cases in which she had participated. So saying what DCF was required to do or what an investigation would have potentially uncovered was outside of her scope and was not provided any support for her ability to testify about that. In the alternative, Dr. Bartholomew did testify that the Academy of Pediatrics does require an investigation if a child is not growing, something that she would have direct knowledge of as an expert in pediatrics. Additionally, instead of saying what the investigation would have uncovered, she testified based on her review of the records and her review of the doctor's notes that there was no investigation by the medical staff caring for this child into why she wasn't growing. And that was her main point throughout her entire testimony, was she believed that the medical providers failed this child. It was very clear throughout her testimony that that was her opinion. Finally, the district court's issue with the term medically negligent came down to the multitude of meanings for the word. And due to the fact that Dr. Bartholomew apparently wasn't available to come participate in a Daubert hearing or testify about what specifically she meant by that, there were potential issues that could not be addressed prior to her testimony.
Would it be fair to say from the state's point of view that this defense was effectively an intervening / superseding cause defense? In other words, that the defense was the professionals who were involved with this child should have initiated an investigation. If they had, the child would have been removed from the home. And if that had happened, the child never would have died. And that strikes me as a claim that the real cause, the intervening cause is this medical negligence, this failure to investigate. And if that's correct, is that an appropriate thing for an expert to be able to testify to?
I think it's difficult to say whether this is a defense of an intervening cause or
I don't think they framed it that way, but that's how it appears to me.
It's almost both an intervening cause argument and not. And I think that's the difficulty with it because
Well, let me just, I'm sorry to cut you off, but let me just cut to the chase, or at least where I was headed with this is, given the facts as they were presented, the evidence as it was presented, even if all of that was true, what the expert wanted to testify to, as a matter of law, could that ever be an intervening cause in a felony murder trial like this?
I don't believe so, Your Honor. And the main reason for that is because despite what the medical professionals maybe woulda, coulda, shoulda done for this child and the number of times this child appeared before her, the main caregiver in any child's life is the parent.
Yeah, I just can't see how that could ever be a defense to child abuse / the killing of a child, because there may have been red flags in many kinds of cases. Oh, and you could always sort of say, well, they should have taken the kid away from me if they had been doing their jobs. It just strikes me as that's not a legally available defense under these facts.
I would agree with you.
Sounds like you agree with that.
I agree with you, Your Honor. And I believe that issue was raised below, but I don't know that it was ever directly addressed. I know that the state filed a motion regarding that defense and raised it as the defendant could not proceed with an intervening cause defense, but I don't know that it was ever, I can't recall from the record that it was ever directly addressed. But throughout the trial, defendant's theory was that somebody should have done something despite his failure. Somebody else should have done something. And that was clear through his cross-examination. That was clear through his direct evidence presented. And that was clear in his closing arguments. And despite his defense, the jury did not believe him. The jury believed that he failed his child and convicted him of those crimes. And any limitations that were placed on his expert's testimony were quite minimal, as she was still able to testify about her opinions regarding any failures that she believed occurred in the system, and still said he's not free of culpability. So it comes down to whether or not he was given a fair trial, whether he had his right to a fair trial, and he did. Your Honors, I will stand on my arguments in the brief and my belief that the second issue can be dealt with a nunc-pro-tunc if there are no other questions.
Any other questions? Thank you, Ms. Smith.
Thank you, Your Honors.
Ms. Patty, you reserve 3 minutes.
I don't know that I really have a lot to add. Just because it came up, I have a complete copy of the district court file, so I'm not really sure where it would be in the record on appeal. I just quickly found it. The state did file a memorandum of law regarding extraordinary intervening cause of victim's death on March 27th, 2023. So I assume that that's someplace in the record. Again, there wasn't one discrete acute event. There were a lot of people who failed this little girl. Mr. Exon requests that you reverse the district court and remand this case for a new trial.
Any further questions, colleagues? Thank you very much, Ms. Patty.
Thank you.
That concludes our 9 o'clock docket. Court will be in recess until 10:30. Thank you.